We're now going to go to Kate Coleman, who's from the UK. She's the founder of Keep Prisons Single Sex. So welcome, Kate.
I'm going to outline the situation for prisons in England and Wales and also discuss the recent judicial review, which we had at the beginning of March. So before I do that, I want to make a quick, possibly quite obvious distinction, but nevertheless, it's still quite helpful between actual sex, legal sex, and self-identified sex / gender identity. So actual sex is your sex as registered at birth. Legal sex may differ from your actual sex in the case where an individual has obtained legal recognition of acquired gender via the Gender Recognition Act 2004 and has obtained a gender recognition certificate. In that circumstance, the sex marker on the birth certificate will be changed. So legal sex is whatever it currently says on your birth certificate, and that may differ from your sex as registered at birth. Self-identified sex / gender identity is where someone hasn't gone through the legal process of obtaining a GRC, but some documentation, including your passport and driving license, can still have the sex marker changed on the basis of self-ID. And I think that's something that quite a lot of people don't realise. And that was one of the issues that was the issue which came up in the judicial review that Fair Play for Women brought in regard to the census. I don't want to go into the GRA too much, except to say that there's no requirement for any surgery or medical treatment in order to obtain a GRC. So what this means is that you can have a wholly intact, fully functioning biological male who is nevertheless a legal female and whose birth certificate states female. And obviously there's absolutely no requirement for any treatment whatsoever in order to self-identify. I just want to quickly drop in the Equality Act here of 2010. So the protected characteristics include sex and gender reassignment. The starting position is that you're not permitted to discriminate on any of these protected characteristics. However, the single-sex exceptions allow for all males, including those with protected characteristic gender reassignment, to be lawfully excluded from single-sex spaces, services, and communal accommodation for females where this is a proportionate means to a legitimate aim. So in that set of circumstances, discrimination is lawful. The current Ministry of Justice policy on transgender prisoners dates from 2019. I'm just using the word transgender here because that's what the policy is called. I just call them all men. Allocation is initially on the basis of legal sex. So what that means is that all men with a gender recognition certificate must initially be housed in the female estate in the general population. There's no consideration given to their offence, their offending history, or their anatomy. All men without a GRC, but who nevertheless identify as women, must initially be housed in the male estate because that's their legal sex. If such a man then wants to be transferred to a women's prison, he can apply and it will go before a transgender case board, and they will consider, allegedly, risk to women, risk to the prisoner, conviction, offending history, etc. And he may well be transferred. There's an important point here about data collection, and the Ministry of Justice has set itself up to just make a complete mess of data collection, which is forever true and can never be undone. Because what they've done is that men with a GRC are always recorded as women or female and only as women or female. This is in all data and all records. Men without a GRC are recorded as men, male, and additionally as transgender. So what this means is that any data the MOJ produces on transgender prisoners will only ever include those without a GRC. That's in terms of prison population, it's in terms of assaults within the female prison estate. It will never include those with a GRC. So what do we know? We know from data which was supplied by the Ministry of Justice last year in response to Freedom of Information Access requests submitted by Fair Play for Women, that as of the data collection point for 2019, there were 11 males with no GRC held in the female estate. Number with a GRC, unknown. 57% of the 129 males who identify as transgender and who are held in the male estate have at least one conviction for sexual offences. This is obviously out of all proportion to female prisoners, where the rate of conviction for sexual offences is around 3%. And it's also far in excess of the rate of conviction for sexual offences for men, which is around 18%. So yes, we're talking small numbers, but these are the numbers we've got. So we're looking at a prisoner cohort, which is quite unlike even men. It's quite unlike any other. So in March, at the beginning of March, a judicial review was heard in the High Court. And I want to look at the prisons policy in light of this, as it shows some of the legal issues, including human rights law, at stake here, and also the Ministry of Justice thinking around these issues. The judicial review was brought by a female prisoner who was sexually assaulted by a male prisoner with a GRC who'd been convicted of serious sexual offences and who was housed in a women's prison with her. As at the time of the judicial review, this male prisoner was still housed in a women's prison in the general prison population. The female prisoner challenged the lawfulness of the policies that permit males to be housed in the female estate with reference to the Equality Act and the Human Rights Act of 1998. Article 3 of the Human Rights Act states that no one shall be subject to torture or to inhuman or degrading treatment or punishment. The argument here was that housing male prisoners in the female estate violates women's Article 3 rights because it exposes them to a risk of sexual assault that would not arise otherwise. Now, what's important to note here is that Article 3 is an absolute right. So this means it can never be negotiated and it can never be set aside. There's also a minimum threshold of severity that must be proved. Article 8 concerns the right to respect for private and family life. This is not an absolute right and can be interfered with as is necessary in accordance with the law in a democratic society. And we'll see that this is important later on when we look at how the Article 8 rights of males who want to be housed in the female estate has been interpreted. So the argument in the judicial review here was that accommodation in a mixed-sex environment is not an ordinary consequence of prison life and cannot be justified as necessary in a democratic society. Article 14 prohibits discrimination, including on the grounds of sex. The argument here is that although the Ministry of Justice claim that the policies regarding transgender prisoners are neutral in that they apply both to the male estate and to the female estate, and that in any case they don't apply to female prisoners, they only apply to transgender prisoners, nevertheless, we know that women who identify as transgender, whether or not they've got a gender recognition certificate, are never held in the male estate because suddenly the reality of immutable biological sex becomes self-evident, very important, and it's a risk that nobody is prepared to take. Nevertheless, were females to be housed in the male estate, the impact on male prisoners is wholly unlike the impact on female prisoners of housing men with them. So according to the Equality Act, the argument was that the Secretary of State for Justice did not take account of the single-sex exceptions that permit all male prisoners, even those who identify as transgender and even those who have a gender recognition certificate, to be excluded from the female estate. Less intrusive options to house this group of prisoners safely were legally available to the Ministry of Justice, but these were rejected. So the defence barrister, made some quite interesting points, which I think really reveal the Ministry of Justice thinking on all of this. So with regard to the Equality Act, the defence claimed that the single-sex exceptions are merely statements of permission. They're not any statement of obligation. The legal starting point is non-discrimination, and in meeting this obligation, a decision maker is free to ignore the single-sex exceptions entirely or to implement a higher threshold for excluding males. The defence argued that this meant that the policy is fully consistent with the single-sex exceptions. So whilst it is correct that these are statements of permission, they're not statements of obligation, the Article 3 rights, which are that nobody should be subjected to inhuman or degrading treatment, these are absolute and they're obligatory on all service providers. So the single-sex exceptions give you a legal way to meet those Article 3 obligations. So you can't just wriggle out of it by claiming that, well, it's just a statement of permission. Yes, it is permission, but it's a legal permission in order for you to meet your legal obligations under another act. The defence also argued that, I thought this was particularly raised my eyebrows, that women in prison will inevitably be exposed to all kinds of people representing all kinds of different protected characteristics from all kinds of backgrounds, and they simply can't just pick and choose which groups they do and do not associate with because it's prison. It was kind of verging on the, well, you know, you're going to be exposed to old women, you're going to be exposed to Black women, you're going to be exposed to lesbians, so you'll also be exposed to women who have the protected characteristic gender reassignment, i.e. men. It seemed that wasn't exactly what the defence barrister said, but it was very reminiscent of that kind of argument that we see elsewhere. And to me, that just really seems to be quite a desperate move to get around the issue. And again, it just completely ignores the absolute Article 3 rights of women. Housing male prisoners in the female estate has quite often previously hinged on the Article 8 rights of these men, which is the right to respect for private and family life. That to deny them this would infringe on these rights that they have. Now, where this takes precedence over the non-negotiable absolute rights of women not to be subjected to torture, inhuman or degrading treatment or punishment, I think we really see the crux of this matter, which is throughout this, women are seen as lesser, not fully human, and that their rights are just simply unimportant. So, as we know, the MOJ collects no data on GRC holders. The defence explained that this is because the MOJ believes that to collect data on GRC holders and to identify them as such could be a criminal act in accordance with Section 22 of the Gender Recognition Act. Section 22 prohibits specific people in specific circumstances from disclosing information concerning someone's gender recognition status. The judges in the JR were frankly incredulous that no one knows how many GRC holders are in prison, particularly as there is a policy relating to GRC holders. As one of them said, well, if you don't know how many you've got and you don't know who they are, you haven't got a policy, you've just got a piece of paper. Article 8 rights are often cited here. However, for the purposes of safeguarding and risk assessment, the right to respect for private life must surely be capable of lawful infringement. I believe that there hasn't been a single prosecution under Section 22 of the GRA. However, it's clear that it has a chilling effect, which results in a can't ask, won't tell situation where someone's assertion that they have a GRC, or at least their refusal to say whether they do or not, is not challengeable for fear that to do so will be a criminal act. But this is just nonsense. I think that the application of Section 22 needs challenging in the courts. I find it difficult to believe that prison staff may not record and use GRC status for the purposes of safeguarding and risk assessment, and I find it impossible to believe that this could be successfully prosecuted. As I said earlier, I think that the Article 8 rights of this group of men, rights that, yes, they are important, but they're not absolute, and they can be lawfully infringed where there is adequate justification, have been promoted to the status of non-negotiable, absolute, inviolable rights. By contrast, the absolute non-negotiable rights of women not to be subjected to inhuman and degrading treatment have been downgraded to at most a mere afterthought. Going forwards, I think we need to shore up the single-sex exceptions in the Equality Act with direct reference to the non-negotiable absolute Article 3 rights of women. A service provider just simply can't wriggle out of their Article 3 rights. So if you don't want to have single-sex spaces, well, that's fine, but human rights law is still going to go against you. In tandem, I think we also need to seriously challenge data collection. It simply cannot be the case that a man's Article 8 rights to respect for private life, nor a provision in the Gender Recognition Act, renders safeguarding and risk assessment impossible. I'm curious about the perspective on trans women who transfer out of women's jails as they feel safer in a male facility than they felt at the women's jail. There are reports around the abuse and harassment from women to the trans women. My position is that all prisoners and all male prisoners have an absolute right to feel safe and secure in prison. And I know that this is a big issue about prison safety. There are many groups of male prisoners who are vulnerable, gay males, old males, disabled males, ill males, effeminate presenting males, as well as those who identify as transgender. In all cases, the solution to keeping males safe in prison needs to be addressed by the male estate, in the male estate, using resources that are earmarked for the male estate. And that's all I have to say on it.